International law shapes war, trade, human rights, climate policy, finance, technology, and migration. It influences what states can do, what corporations must do, and what individuals are protected from, often across borders, cultures, and legal traditions. Yet for something so powerful, international law is often described as weak, fragmented, or even optional. So what is the international legal system? How does it function without a world government? And what does all of this mean for lawyers practicing in an increasingly global, fast-moving world? Let's find out. Domestic legal systems are built vertically. There's a legislature that makes the law, courts that interpret it, and an executive branch that enforces it. International law is horizontal. States are legally equal. No state is above another. There is no global parliament with universal authority, no standing global police force, and no single court with compulsory jurisdiction over everyone. Instead, international law operates through consent, cooperation, and coordination. For lawyers, this creates a system that is simultaneously sophisticated and unstable, structured but always contingent on politics, power, and compliance. Traditionally, states were the primary subjects of international law. They made the rules, enforced them, and violated them. But that's no longer the full picture. Today, international law also governs international organizations like the United Nations, World Trade Organization, and World Health Organization. Corporations, especially in trade, investment, sanctions, and human rights contexts. Individuals through international criminal law, refugee law, and human rights regimes. This expansion has dramatically increased the complexity of legal practice. Lawyers now operate at the intersection of domestic law, international obligations, regulatory frameworks, and transnational enforcement mechanisms, often all at once. International law doesn't come from a single code. Instead, it draws authority from multiple sources. First, treaties. Treaties are written agreements between states. They can regulate everything from maritime boundaries to investment protections to climate commitments. Once ratified, they bind the parties under international law. Second, customary international law. Custom emerges when states consistently behave in a certain way and believe they are legally required to do so. This is how rules like diplomatic immunity or the prohibition of torture became universally recognized. Third, general principles of law. These are foundational concepts like equity, good faith, or procedural fairness, shared across major legal systems. For lawyers, identifying which source applies, how authoritative it is, and how it interacts with domestic law is often the core challenge. International law does have courts, but with limits. The International Court of Justice resolves disputes between states, but only when states consent to its jurisdiction. International arbitration plays a major role in investment disputes, commercial conflicts, trade disagreements. Meanwhile, international criminal tribunals address genocide, war crimes, and crimes against humanity, but only in specific contexts. Crucially, domestic courts often become the frontline enforcers of international law, applying treaties, customs, and transnational regulations at the national level. For lawyers, this means international law is rarely somewhere else. It shows up in contracts, compliance reviews, litigation strategy, and regulatory advice every day. One of the biggest myths about international law is that it's unenforceable. In reality, enforcement is diffuse, not absent. It happens through reciprocal state behavior, economic sanctions, trade retaliation, reputational pressure, domestic court judgments, compliance mechanisms built into treaties. But this system places enormous responsibility on legal professionals. Missed deadlines, overlooked reporting requirements, or poor documentation can escalate into international disputes, financial penalties, or regulatory violations. International law rewards preparation and punishes disorganization. Now let's talk about lawyers. Today's legal work is faster, more global, and more mobile than ever before. Clients expect immediate updates. Cases involve multiple jurisdictions. Deadlines span time zones. Documents live in the cloud, on phones, and across teams. Yet many law firms still rely on fragmented systems. One tool for cases, another for billing, another for clients, another for internal operations. In international practice, fragmentation creates risk. When information isn't centralized, lawyers lose time, clarity, and sometimes credibility. International law isn't just about knowing the rules, it's about tracking obligations, managing documentation, coordinating teams, communicating with clients, staying compliant across borders. This is where legal operations become legal expertise. Try Legalizer today.